And as soon as we resolve this, I'm prepared to postpone it. So.
All right, okay, thank you. It's Wednesday, the middle of the week. All right, Zachary Gilmore. Well, Mr. Woodard, how's it going today?
It's going well yourself.
Oh, I cannot complain. It's Wednesday. You know, we're all currently alive. A little bit. See, it's the zombie apocalypse upon us. Okay, Odyssey is being crazy. Just give me a moment. I just need to pull up your case. And I know it's concerning an early termination.
I'm not sure if the court has a status report.
Let me see.
Probation gave me a copy of it this morning.
All right, let me see if I have it. Is there any objection to the court reviewing that?
Not from the state.
Okay. See that. See, we're gonna have a problem with Odyssey. And then, No, I mean, it was restarted. So I don't know what is going on here. I'm gonna try again. Ah, here we are. Yay. It's the little things. You learn about that when you become an adult. Okay. Well, I don't think it's going to pull up. So let me see.
That first week for me, yeah, that's great. Well, I'll have it maybe a couple weeks, maybe.
Lewis, your other, right?
And on this.
It's released, right? It's released. No longer in there. Oh.
Well, that solves everything.
All right. Court is calling 2024 CR 0963 State versus Zachary Alexander Gilmore. Could our parties announce?
Rick Pena for the state of Texas.
David, I'm David Woodard for Zachary.
And are you Zachary Gilmore? Yes. All right, defense, you're here. I think probation submitted a report to the court asking for an early termination, and this is a misdemeanor case. All right, state you're opposed.
We are at the
concerned and request of the victim. We did our best to bring her in here so that she can voice her concerns to you as well. And we let her know that Zoom would also be an option. She didn't want to do either, though she just wanted us on her behalf to voice her concerns to you, that she's not okay with the defendant being released early from his probation, that in her mind, justice on her behalf would be for him to serve the full 2 years of his probation.
All right, so here's my question, and I don't know if you're the prosecutor who did it or not. Why was this reduced to a misdemeanor? Does anyone know?
I can
It
look at
wasn't
the,
this prosecutor, Judge. I forgot the prosecutor I was
Uh,
dealing with.
Okay,
But it was
the
a
one
gentleman.
that's on the judgment is Zachary Dunn.
Correct.
what was that?
That's what I
So-
heard with.
Does anyone know why it was reduced?
I can try and figure that out right now if you give me a second. Charlie.
And if I may, Judge Proctor,
Yes.
During our negotiations with Mr. Dunn, after he spoke with the victim, there were some issues with her testimony, what he thought would come out at trial. So he offered me a reduced misdemeanor.
Mhm.
So that was the gist of why it was reduced down.
And the reason why I'm asking these questions, because sometimes cases are reduced because the complainant doesn't want to go forward. So I'm just trying to figure out what the reason was behind it.
No, she was cooperative, Judge. It was just after he debriefed her, there was some issues with her testimony that he thought would be contradictory at trial.
That very well could be. Mr. Dunn unfortunately didn't put his notes in here, so I can't see why he wanted to reduce it, but if that's what it was done, I'll take Mr. Woodard's word for it.
All right. So probation,
Yes,
has he completed everything?
client, all fees have been paid, all funds have been there.
All right. And has he had any contact with the complainant?
Where
Not that the state's aware of either.
have any notations or anything that anyone gets called about him or anything.
All right. Do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Zachary Gilmore.
All right, what have you learned?
What I've learned is the main thing is to trust more in my family and parents. I don't know if it was just youth or being hard-headed, but when this relationship was tumultuous, instead of going to them and seeking help, I decided to remain silent, and it escalated from there.
What do you mean you decided to remain silent? What are you talking about?
When we would be argumentative, have huge fights, get thrown out of the house, I would just essentially just suck it up, not say anything to anybody. I didn't want to reach out for the help that was needed. And I clearly know now that I should have reached out to my parents. They have a wealth of knowledge. They could have helped, whether that be mending the relationship, making it stronger, or telling me I should have gotten out of it. Then through Miss Kathy, the bit course that I did take, she kind of broke down why therapies are don't have to be stigmatized for men. So I've looked into therapies like BetterHelp, and then clearly I don't want to be in the situation again, which is probably the biggest thing. I mean, it's quite scary, taking away your freedoms and stuff like that. So I never want to be in the situation.
All right, so according to the police reports, you were intoxicated. How have you addressed that issue?
We were celebrating. I believe Miss Bueno had gotten a promotion. That's not something that is normal for me. I don't feel like I have any drinking issues. Now, of course, that's besides the point because I was intoxicated. Everybody was intoxicated. It's certainly something that I take into account now, drinking alcohol, of course, being on probation, staying away from it. But moving forward, it's not something that's needed. I mean, it's literally a poison. So just staying away from it is the way. I've trusted thus far and moving forward.
All right, when's the last time you drank alcohol?
That night,
And have you had any contact with the complainant?
no, ma'am.
Any contact with her family?
No, ma'am.
All right.
Just one more thing, if I might, Your Honor, I forgot
Yes.
to make one more point that the victim wanted me to mention was that the defendant hasn't even been on probation for a full year. She just wasn't okay with that.
He has
No,
gone
he's-
for your judge.
He was placed, I'm pretty sure probably they received a call from her before it was a year. So, because I think he's reading off synopsis. But counsel, he was placed on probation July 1st of 2024.
Okay, so that's my apologies.
No, no problem. I know how when stuff is placed in synopsis, it's the last conversation that somebody had with a witness and you read from there. So, all right. So here's the thing. There are sometimes I grant people early termination, sometimes I don't. It really depends on what the person has learned, whether or not they've been compliant throughout their probation. And so the report that I'm seeing is that he's been compliant throughout probation. My understanding is that probation is designed for rehabilitation. And if a person is rehabilitated, then why do we have them remain? And I know sometimes people will say, well, he got a good deal or he already got a benefit because it was reduced to a misdemeanor. But from Mr. Woodard's rendition, there's a reason it was reduced to a misdemeanor. And if he's being told that, hey, this is a happy medium for everyone because there are some issues with the complaint, there will be issues with the complainant's testimony, then for the court, that's the reason that I'm being presented why it was reduced from a misdemeanor. So I know sometimes people will argue they've received the benefit by having it reduced to a misdemeanor, so they should do the whole 2 years. There have been some people in this court that have been placed on misdemeanor probation where I said, no, you're going to remain on probation. And usually it's because I don't think they've internalized what has happened. And I don't think they understand or accept their responsibility and how they came to be in the situation that they're in. In this case, it appears that Mr. Gilmore has accepted responsibility for his actions. And I know that when you are in therapy, not that I've been in therapy for domestic violence, but I have gone to see how the classes are enacted. And I know that when you receive the BIP course, they don't just talk about your actions as far as the physical abuse that you place upon somewhere else. They talk to you about relationships. They talk to you about healthy relationships and what is a healthy relationship. And I do know that sometimes when men are abused, they don't want to talk about it because their whole thing is, but I'm a man. I shouldn't be abused by a woman emotionally, physically, or any type of way. So I understand that. So I hope that you continue with your therapy. I'm going to grant the motion for early termination that's been presented to the court by probation. Probation has stated that you have completed everything. You've internalized everything. You received a certificate from the BIP course, which tells me they believe you've internalized everything. You've learned everything. But I will tell you this. You're not allowed to, it's continued, no contact with her, you understand? And this is an affirmative finding of family violence. So that's going to be on your record forever, the affirmative finding of family violence, which means you're not allowed to own or possess any weapons. Do you understand?
Yes, ma'am.
All right. Is there anything else?
No, Your Honor, thank you.
All right. You're welcome. Good luck to you.
Thank you, ma'am.
You're welcome. All right, anyone else ready? Who is here on Alex? I'm sorry, Alexis Hernandez? Ah, okay. So there's nothing to do with that. All right, and Norma, if you can call those other attorneys, they need to be here.
Yes.
All right, so. Norma, if you call David. All right, so David, are you ready or no?
My client is speaking with his family about the offer, and I'll
Okay.
let the court know.
All right, thank you. Then if y'all are ready to start on this other hearing.
Yeah, sure.
Mhm. Yes. Thank you. Yes. Bashan, I cannot begin to express how much more comfortable this chair is. The back support is awesome. Because the other one, it was supposed to provide lower back support, but it didn't. And after about 6 hours in, I could really feel it.
Has a massage in there too.
No, okay, this is the government. Of course, this chair is not a massage chair. Come on. And then I would feel so guilty even asking for a massage chair. I was like, no. Yeah. Yeah. Well, people always think I'm sleeping when I'm actually reading. And everybody says, you're so still. And I'm like, I'm 100% concentrating on what I'm reading. Hello. Sure. All right, and could I have the file for this case, please? That's for this sentencing. And Deputy Laura, can you let him sit next to his attorney? And Rick, I think where we left off, the complainant had finished her testimony. Is that correct?
We have rested, yes, Your Honor, so this is defense
Okay.
and their witnesses.
And defense, are your witnesses present?
Your Honor, unfortunately, there was a mix up with my office, so his family isn't able to be here right now.
Well, do you want to see if they can appear by Zoom?
Yes.
All right, so if you'll call them and see if they can appear by Zoom, and Ms. Ferguson will give you all the Zoom link.
Thank you, Judge.
State, you don't have any objection to the witnesses appearing by Zoom?
No, Your Honor.
All right, thank you.
And I'm gonna call my client so that
Sure.
we can.
In a few minutes, yes.
Mhm.
Thanks, Norma.
For this one.
Okay, that's that one.
You get it?
And here's his file. Sorry about that. Norma?
Yes.
Uh, I guess this is Alexis Hernandez. My understanding that they've made bond. Is that correct, Deputy Laura? So I need a reset for 30 days for discovery. And Rick, are you all on this case or is this a special division? It's the stalking case?
Ours.
All right. So if I can have a 30-day reset, please. Okay. Sure. Sure. If y'all could give me the file on Aguilar, please. All right, Juan Aguilar. Hello, good morning. All right. All right, today is your plea deadline date. So defense, has there been an agreement or no?
There had to be, Judge.
All right, so your next, bless you. So your next date is going to be jury trial. So do you want a jury trial or bench trial? What I can tell you is if you come to me for a bench trial, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. So jury trial or bench trial?
Jury trial, Judge.
All right, Norma, this should probably be 3 days, and that includes jury selection. I need a jury trial date. Okay. All right. It's family violence. And if you all could make sure that I have an acknowledgement of discovery signed, please. All right, September 23rd. Once you sign the reset form, your excuse, thank you for dressing appropriately for court. And counsel, if you'll make sure the acknowledgement of discovery is completed before you leave.
Move it, Judge.
All right, thank you. You're welcome. All right, and on this case, you all said you're going to call your client first?
Yes.
All right, just let me put this in the system, then we'll go on the record.
Sure. You want to do it?
Cindy, you ready?
Yes.
Court is calling 2024 CR 06930, State versus Alexander Rodriguez. Can I have parties announced for the record, please?
Rick Pena and FC Jones for the state of Texas.
Clarissa Fernandez Pratt and Marissa Giovanco for Alexander Rodriguez.
All right, and are you Alexander Rodriguez?
Yes, sir.
All right. Where we left off, I believe, state you had rested, is that correct?
Sure.
All right, he may take the stand. All right, sir, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Alexander Rodriguez?
All right. And Cindy, are you able to hear him okay?
Yes.
All right, defense, you may proceed.
Alex, can you please tell the court what you were doing before your arrest? For a living?
I was working at a paper company.
I don't know if your microphone is on.
Can you move it maybe to your?
Oh, can you put that on? Thank you. Have your microphone down.
All right, if you'll just speak into the microphone. All right, you may proceed.
For a paper company.
Okay, and what were you doing there?
We'll make cardboard boxes.
And how long have you been doing that?
Going on 3 to 4 years.
Okay. And were you a good employee?
Yep.
Okay. Now, you heard the testimony of Emily and Clarissa. Did you agree with their testimony?
No,
Okay. Let's start from the beginning. You were in prison, correct?
yes,
Okay. What were you in prison for?
for a arson charge.
Okay. How old were you when you picked up that arson charge?
I was 15.
Okay. Now, tell the court what happened, why you did what you did.
Basically, I was young, naive, and I thought I was in love at the time with Clarissa, Emily's mother. She thought I was having an affair with the girl next door, and then she was basically telling me that we shouldn't be together and everything because she thought I was having an affair. So she basically wanted me to prove it that I didn't have an affair with her.
So she wanted you to prove your love and devotion to her.
Yes.
Okay. And what did you end up doing to the house?
She suggests to start a fire in the house.
Okay. And this was no secret, right? This was, she knew about it, her mom knew about it, everybody knew about it,
About what?
about the fire.
They did, yes. Everybody knew about it.
Okay, and then CPS also got involved. Okay. So then, did anyone get hurt in the fire?
No, I know, I think there was a dog, if I'm not mistaken, but I think the cage and everything was open and the door was open for the dog.
Okay.
So sadly, yes, I think the dog did decease.
Did pass.
Yes.
Okay. So you were 15 years old and you got sentenced for how long?
20 years.
Okay. When were you released from prison?
The end of 2013.
Okay. So in 2013, you were released from prison. And when did Emily say the abuse started?
While I'm incarcerated.
Okay. So while you were incarcerated, she's claiming that she was sexually abused by you.
Yes.
Okay. Tell me about your time in prison. Did you get into any trouble?
No, I did get in one trouble, I think, for having like contraband and stuff like that. But that was it. And basically was good.
What was the contraband?
I honestly don't remember.
Okay. And so how much?
I'm so sorry to interrupt. But was his testimony that during part of the complainant saying that he was abusing her, he was actually in custody?
Correct.
Does anybody want to tell me or obtain from the witness what dates those were, or somebody has dates for the court? And I hope there's no objection from any party for the court wanting clarification since sentencing is coming to the court.
And
Any objections?
Not
From
from
the
the
state?
state, Your Honor.
And any objections from the defense to the
No.
court wanting clarification?
no, Your Honor, and we have the TDCJ reference. Okay. So specifically, do you recall being released, I think. Let me see, your judgment says that the judgment was entered February 26th of 2010, correct?
So what again, sorry?
The judgment, like when you were actually sentenced in 2010, right?
No, I think it was in 2008.
That was the date of the offense.
Oh, then.
All right, sorry to interrupt. Does anyone have the judgment and is there going to be an objection to the court reviewing the judgment?
It was previously entered into evidence at the last time as State's Exhibit P1,
All right,
and that was a certified judgment from the clerk's office.
all right. And let's pause for a moment. Cindy, are you able to pull that judgment?
I can reprint out an unofficial copy if defense has no objection to that if she doesn't have it.
No, I have no objection, Judge, and staff is bringing the TDCJ records to show what the contraband was and the date of release. And it's a certified copy. So,
Just 1 second. We're off the record. So
I
Can
guess
someone- they're saying they're not going to object to the court reviewing if you all have
okay.
something.
If you want, I was just gonna pull it and print it, but it's up to you.
It's 42 pages.
Oh, the whole thing?
The whole thing, yeah.
Oh, okay.
Oh, no. I just want to see the time where y'all are
She
saying
wants
that
the
he's in
judgment as
custody.
the
Of
first-
course, if there's something else you would like to enter into evidence, the court will view it.
Yeah, it's,
If you need me to print it first, just send it over. I'll print it to the Bexar printer, so we don't take up this printer and I'll have Sarah get rid of it.
Ashley Jones. A. Jones, right?
A. Jones. Yeah.
Important.
And
Right.
we're back on the record. You may continue.
Mr. Rodriguez, during your time in custody, did you,
Was the rule involved? Because we've got witnesses who are in the court.
we've already rested and
well, they're subject to recall, one of them is.
No, I know they were in, sorry, they were in the first part of the hearing. If you have an objection now.
I think we had.
couldn't remember.
Wait,
Okay,
yeah,
we were
sorry,
here last time.
sorry, okay, it's okay if you have an objection. No, I just didn't.
Do you recall while you were in custody, from 2008 until 2013, receiving a procedure on your sexual organ?
Yes,
Okay, and what was that?
basically, we got dominoes is what we put in our penis, basically. And
What does that
then,
mean?
so basically, we'll, in making the solution, put like a shape or whatever of a domino inside the penis.
Okay,
I
Is that-
had gotten 3 pearls at a time
okay. And where were they located?
on top of my penis.
Okay. Are they hard to the touch or soft?
Hard.
Are they fairly noticeable?
Yeah, you can easily tell they're there. You can see them, feel them, and everything.
Okay. And did you have them when you went into prison?
No,
And you had them when you were released from prison?
yes,
And so, when you heard Emily's testimony that she didn't feel them during the alleged abuse, how did that how do those two things coincide?
Basically, kind of like, how do you not realize you don't feel that at all because it's very noticeable?
Okay. Did you sexually abuse Emily?
No,
Why do you believe that she's saying these things?
Objection, Your Honor, speculation, relevance.
That'll be overruled.
I honestly don't know.
Now, you heard Clarissa testify that she was afraid of you after you were arrested for the arson.
Yes,
While you were in custody, did she write you several love letters and messages and letters for years?
Objection, Your Honor, relevance.
Overruled.
yes, we had stayed in contact.
May I approach the witness?
Yes.
Are these the letters that you received from Clarissa?
Yes,
And you recognize her handwriting?
yes,
Are they a true and accurate depiction of the letters that she wrote to you?
what?
A true and accurate depiction of the letters that she wrote to you while you were in custody?
Want to say yes? I don't know what true discrimination or what.
True and accurate depiction, meaning are those the actual
Oh,
copies
yes,
of the
yes, yes,
letters
yes.
that she sent you?
Yes,
Okay, and did you keep those?
yes,
Okay. And have you amended them in any way?
no,
Okay. I move to admit, I don't even know what number we're on. Defense sentencing exhibit.
Did you enter in previous defense exhibits? Who's opposing your
I think
first
I
one?
Do you know what number we left off on? My documents are real.
Oh, you
I can go
can,
look.
all right.
She's doing that.
Okay.
Take a look for hers.
Yeah, go ahead. Did you sign off?
There, can you hold on? TDCJ. One night, the students off, not. Okay.
Don't.
Y'all. This is the fee. Sure. No, there's these. Turn. Here. This is the one. There's no jump. That's rules. I'm not sure.
I'm marking it as defense punishment exhibit 2.
And for the record, are those letters?
They're letters from Clarissa for purposes of impeachment of her testimony that she said she was afraid of Mr. Rodriguez.
And state would object as that being improper impeachment. It's also hearsay and relevance.
All right. Your objection to relevance is overruled. The hearsay objection will be sustained. Could I, just one moment.
Released from prison, where did you go after that?
Until a halfway house
Okay, and where was the halfway house?
in Corpus. Corpus Christi.
And then you didn't see Emily until after you came back to San Antonio, is that right?
Yes.
Okay, and where, do you know where Emily was living in 2013?
I wanna say maybe with her mom, but I know sometimes she'll go with her grandparents or live with the great grandparents sometimes.
Okay,
She went like hopping back and forth sometimes with them.
okay. But you didn't start seeing her until when?
Objection leading, Your Honor.
Overruled.
Not till after I was after the halfway house and eventually moved to San Antonio.
Okay, when was that?
I wanna say sometime around 2014, but then I know I also had to try to put myself on child support so I can be able to see Emily.
Okay. And so you, so if the original petition in suit affecting the parent-child relationship was filed March of 2015, does that coincide with your testimony?
Yes,
Okay, so you only started seeing her after you filed your petition?
yes, I saw her a few times before, but that was only here and there. A lot of times she didn't want me to see him because she thought I wasn't financially stable and everything like that.
Okay. And at this time, who were you living with?
I was living with my mom's.
Okay. And so Emily her date of birth is November 11th of 2007.
11/11/07, yes.
Okay. And so in 2015, she would have been 8 years old?
I'm not sure.
Okay. And so there's no way you were around her when she was 6, right?
Objection leading, Your Honor.
Overruled.
No,
Okay, and then in 2014, you still weren't getting visits, is that right?
Objection leading, Your Honor.
Overruled.
And then in the answer to the question was yes?
yes,
So you really only started seeing her in 2015.
yes,
And the indictment in this case alleges that the abuse started in 2013?
yes, before I got released from TC.
Okay. Okay. Now, do you remember Emily getting her period?
I vaguely remember that day, yes.
Okay. Do you know how old she was when that happened?
No, I did not.
Okay. Did you ever discipline Emily, hurt her in any way?
No, I never hit her, spanked her, or anything like that.
What do you make of the allegations that you sexually assaulted her while camping with her family?
Absurd, I want to say the word. I don't know if I'm pronouncing it right.
Do you have your GED?
Yes,
Okay. Did you get it while you were in custody?
Yes,
Okay. And did you provide Clarissa child support?
yes.
Okay.
Everything was off the record.
So it wasn't through the Office of the Attorney General?
No, we weren't able to because technically her parents still, her mom and stepdad had custody still.
Okay. So Clarissa didn't have custody of Emily in 2015, legal custody.
No, because they still had to get her rights back for her first so that we can go to child support for her.
Okay. So, have you been in trouble since you've been in custody here in Brick County?
No,
And, did you comply with CPS?
yes,
Did you ever get a call from the police saying they wanted to interview you?
no, I did not. I didn't get no call, no phone call, no letters. Nobody came to the house. No one even came to my job or anything like that.
And were you residing in the same home for almost the entirety of your life? With the exception of prison?
Yes,
And where did Clarissa's family live in relation to where you live?
what do you mean?
When you guys were growing up, where did Clarissa live?
When we were growing up, her mom lived right across the street. Eventually, over time, she moved down the road to the subdivision right over.
Okay.
And then Clarissa, her house at the time is maybe a mile or so down the road the other way.
Mhm.
And then her grandparents are barely 5 or 10 minutes away.
Okay, so you never, she knew where you lived.
Yes,
While you were having, an affair with Clarissa, did she ever ask you to keep it secret?
Objection hearsay on.
All right, that'll be sustained.
How long did the affair go on for?
for many years.
Okay. And, was Clarissa aware of your pearls?
Yes,
Speculation or objection.
Overrule.
Did she ever talk about your pearls with you?
yes,
Okay, was it ever a topic of discussion?
yes,
Did she? Did Emily still have a relationship with your side of the family?
yes.
Okay, and does she now?
As of right now, I'm not too sure. I've been in here, so I'm not sure who she contacts with.
Okay. And has Clarissa, discussed this case with you?
No,
Has, ever since the accusation came out, has she asked you for money?
yes,
Has she, given you updates of Emily?
yes.
Give me 1 second, if I could have a second, Judge, just for you. When you were, yeah, when you were on parole, did you behave on parole?
Yes,
All right, just one moment off the record. This is what I want to know. I understand on or about dates. And count one is on or about November 2013.
Mhm.
And again, I understand what on or about means. So she's saying he was still in prison in 2013. Is there any stipulations to that, or state, are you saying he wasn't in prison in 2013?
Your Honor, just looking through the document defense has provided, I don't see the time he was released.
It's, I'm looking right now just to verify, but we've got, I think if you go on TDCJ,
On the criminal history record, it's on there for sure, but I don't see it on these.
Your TCI and CIC also says it.
So I want to know if he
Ah.
was actually in prison in 2013 and when was he released? And again, I understand the honor about date, but I want to know because it appears that this is information the defense is trying to provide to the court and there's some sort of documentation. So that's what I want to know. When was he in prison and when was he released? If someone has that information.
I have it, Judge. His release date is November 19th of 2013. He went into a halfway house after his release.
And we're verifying that on the NCIC, TCIC we have.
Okay. All right, and what's the dates for the halfway house?
I'm still looking for it.
And we have confirmed that, Your Honor, he was paroled from prison November 19th of 2013.
Okay, parole, November 19, 2013.
Yes, Your Honor.
And when was he sent to prison?
He was sent to prison. I guess that would be the judgment date, which
Mhm.
from what defense said, 2/26 of 2010.
2/26, 2010.
Yes, Your Honor.
All right, and so when was he at the halfway house?
Immediately upon his release, and Alex can testify, I suppose. How long did you stay at the halfway house?
Well, no.
We're not on there.
No,
We're
we're not on the record at the moment. I'm trying to figure out when are people saying that he was at the halfway house? And where is this halfway house located? Okay, all right, we can go back on the record.
Alex, how long did you stay at the halfway house?
For 3 months
Okay. And where was your halfway house?
in Corpus Christi, Texas. It was off of the road, Concoa, I wanna say.
Okay. And did you basically live there?
Yes.
Okay. Was it a lockdown facility or did you work? How?
We had to stay in there for a month or so for medical programs. Then after that, we had to stay there, but the only time we would leave is for going for work.
Okay.
So we had to stay there for the rest of the months.
Okay. And you didn't see Emily during this period of time?
No.
May I approach Judge?
Yes.
Showing what's been marked as defendant's punishment exhibit number 3. Is this the basic information relating to your TDCJ release date?
Yes.
Okay, I move to admit defendant's punishment exhibit 3.
I would just object on the fact that it's improper authentication. He's not an employee of the Texas Department of Criminal Justice.
All right, if I can see the exhibit, please. All right, so is it correct that both parties have stipulated that he was released or paroled from TYC from the prison, November 19, 2020, 2013. I think you all have already stipulated to that. Is that correct? And it appears this document that is Defense P3, it has the date that he was released. So Do you still have objections to the document?
We'll withdraw our objection.
All right, then, Defense Exhibit P3 is admitted.
Thank you. Do you recall, when exactly you moved back to San Antonio?
I don't know the exact date, no.
Okay, what year?
14?
Did you? Did you receive notification, through CPS concerning, Clarissa's, allegations of abusing Emily?
No,
Okay. Did Clarissa ever notify you that she had that finding with CPS?
no,
Sometime while you were in prison, you lost contact with Clarissa?
yes.
And when was that?
Around the beginning of maybe beginning when I was incarcerated, yeah.
Okay. Did she get married?
I believe so, yes.
Okay. I passed the witness search.
Yes,
I may,
you may proceed.
You testified at the beginning about your arson conviction, correct?
Yes,
And you mentioned that that was because Clarissa was saying that you were having an affair with this person, correct?
yes,
And you said that she suggested to you to do what you did, is that correct?
to do it, yes,
To burn the house down.
yes,
So you took her word over anything that I'm gonna follow, whatever she tells me, I'm gonna burn this person's house down.
yes. At the time, also, I was under the influence of alcohol and everything. I know it's not an excuse for it either, but
Okay, so you were 15 and you were under the influence of alcohol and you decided at that point that the best decision to make to prove that you were not having an affair would be to burn her house down.
yes, I wasn't thinking correctly at the time. And as I said, I was young, naive.
Right. You also testified that you don't agree with either your own daughter or her mother's testimony that was presented during the trial, correct?
Yes,
Even though 12 strangers listened to everything and found you guilty, correct? You
Yes.
still don't agree with that.
yes.
Okay. And you, what was your daughter's date of birth again, please?
11/11/07.
Okay. 11/11/7, so that would mean she would have been about 6 years old in 2013, is that correct?
I'm not sure.
Okay, well, let me help you out with that then. So if you go 2007, 2008, that's 1 year, right?
Okay,
Is that correct?
yes,
2009 is 2 years,
yes,
2010 is 3 years,
yes,
2011, 4,
yes,
2012, 5,
yes,
so then 2013 would be 6,
yes,
okay, and then 2014 would be 7, right?
yes.
All right. And again, her birthday is November 11th, correct?
Yes,
So she's 6 all the way up until she turns 7 in November 11, 2014, right?
2008,
Injection, circulation, I think you.
Oh, that'll be overruled.
13.
Or we just,
So 14, yes, 14 would be 7.
okay, so then she would be 14, she turned 7. She'd be 7 all the way up until she turns 8 in 2015 on November 11th, correct?
Yes,
Okay. All right, so again, you don't believe anything, so are you calling your own daughter a liar throughout her whole testimony?
yes,
You testified earlier as well about this procedure that you had on your groin area, right? So you got the purling, is that what you called it?
yes,
And you had that procedure while you're in custody in prison?
yes.
They allowed those types of procedures while you're in prison?
It's a thing that they do in TDC that inmates do,
So another inmate did it to you, or was it a doctor did it to you?
another inmate,
Another inmate did that to you?
yes,
Okay. Okay. In TDC, right?
yes.
Okay. Was that approved by TDC?
No, it's not a thing approved.
So no one ever found out about it while you were there?
No, I never went to medical for it. I never got no infections or anything like that, never. Yeah,
So then there wouldn't really be a medical record of you getting that procedure then, right?
no,
Unless you voluntarily told someone there that you had this procedure, right?
yes,
Which you didn't do.
yes.
Okay. Um. That's the witness, Your Honor.
All right, any further questions?
Yeah, just one, Mr. Rodriguez, did you in fact ever sexually assault your daughter Emily in any way?
No,
Did you ever touch her inappropriately?
no,
And how long?
Any further questions?
No question, Your Honor.
All right, I have a question if there's no objection.
No objection.
Not from the state.
All right, so what's the date that he's alleged to have gone to the halfway house in Corpus? Does anyone know? And
November,
does anyone have proof of it?
The docket that was admitted that says the release for prison date November.
No, I mean, it has release date November 19, 2013, but this document that's exhibit defendants P3 does not say anything concerning a halfway house.
parole records, let me see if I can pull them up. I'm not sure we got parole.
Unless there's a stipulation of when he went to the halfway house and when he was released from the halfway house.
State will not stipulate to that.
All right, and I understand.
No, Judge, I think we'd have to pull the parole records and I don't have access to that. We were able to subpoena the EDCJ records, not the parole records.
Does anybody want to ask some questions concerning that? And then if someone later wants to provide the court documentation, the court will of course accept.
Mr. Rodriguez, you said you were in Corpus in a halfway house for 3 months?
yes,
Okay, so if your release date was November of 2013, did you go straight to the halfway house?
yes, as soon as we got our TDC, they took us to the Greyhound. And after that, we got drove to from San Antonio Greyhound to Corpus.
Okay,
And then from there, we called the facility and they come pick us up.
so you wouldn't have come back to San Antonio until February of 2014?
Object to
After I had,
Just 1 second. The objection to leading will be sustained.
So three months after November, what day would that
I'm not sure if it's right away after the 3 months. I know I had to get a transfer from Corpus to San Antonio for address. Cause if not, I couldn't be able to leave.
Okay, so you had to get permission from parole.
Yes,
And would the parole records show where you were living and
yes,
Objection speculation.
All right, that'll be overruled.
did parole regularly check in on you?
yes.
Okay.
We did home visits, office visits.
Did you have a monitor or not?
No,
I pass it.
All right, any further questions?
No questions, Your Honor.
All right, you may step down. Vince, call your next witness.
you guys still need the papers over here?
Yes, just leave those there, please.
Read the microphone. Michael.
I'm gonna.
All right, do y'all have your next witnesses?
I'm recalling Emily's mom, Clarissa,
All right,
briefly.
all right, is her mom here? All right. And Scott, are you here for a case?
Just for signature, I can wait, thank you.
Oh, you can bring it forward.
It wasn't important, I didn't need to.
No problem.
Okay, don't forget to put this on your shirt and then adjust the microphone as you need to then.
Okay, so on these, okay, yes.
All
All right, thank you. You're welcome. All right, hello, you're still under oath. Defense, you may proceed.
Ma'am, in front of you, you have defendant punishment exhibit number 2. Are those the letters that you wrote to Mr. Rodriguez while he was incarcerated?
Yes,
I didn't hear you. What was that?
yes, no.
Okay. And you would agree that the letters that are contained in that exhibit, you do not show that you are fearful at all, Mr. Rodriguez, right?
Objection leading, Your Honor.
I'll overrule it. You can answer the question.
No,
Okay. So your previous testimony that you were in fact afraid of Mr. Rodriguez after he burned down that girl's house is incorrect.
Objection leading, Your Honor.
I'll overrule it.
I'm sorry, what was your question?
My question was, your previous testimony that you were afraid of Mr. Rodriguez and what he was capable of doing is incorrect.
I mean, I was always afraid. He literally burned down the house and killed animals. So I was always afraid.
Okay. And so, I'd like to move to admit, defendant's exhibit 2. It's being offered as impeachment, not for the truth of the matters that are asserted in those letters. I don't believe.
They would still object as to hearsay relevance and improper impeachment. They can't use.
All right,
forensic
with
evidence.
regards to relevancy, that will be overruled. With regards to foundation, that will be sustained.
Have they been altered or amended in any way?
No,
Okay. Are they a true and accurate copy of the letters you sent to him?
yes,
Did anyone force you to sign those letters?
no,
Move to admit defendant's punishment exhibit 2.
Same objection, Your Honor. It's still hearsay and still improper impeachment.
All right, with regards to the foundation as it relates to impeachment, that will be sustained.
Okay. Having reviewed the records, are you still of the opinion that you were afraid of him, even though the letters show otherwise?
I wasn't fully afraid, but I was afraid, yes, his actions scared me.
Okay. And you previously testified that you ran away with him after this burning, right?
I'm not sure, I don't think after, I don't remember the date.
But you had run away with Mr. Rodriguez before too.
Yes, when we were minors.
Mhm. Okay, that's the witness.
State,
Just, if I may, just a few questions. You testified that while you may not have been fully afraid of him, you were still afraid of him, and what was the reason for you being still afraid of him in some way?
I was afraid because of his actions, his continuous actions,
What actions were those?
burning the house down. Without thought, that family that lost their home, that lost everything. Killing those animals without even trying to let them out. Trying to claim that I told him to do it, to burn down the house. Trying to claim that I was there with him when I in fact was not. So all these actions did scare me, he frightened me.
Thank you, ma'am. No further questions, Your Honor.
defense,
You still chose to have an affair with him when he was released though, right?
Yes.
Absolutely.
No questions, Your Honor.
all right, you may step down. Just leave the microphone behind. All right, defense, call your next witness.
I call Stephen Shamrock.
All right. All right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
Stephen Shadrock.
All right, you may proceed.
Mr. Shamrock, how are you related to Mr. Rodriguez?
Christina Ontiveros, her mom, she is my domestic partner. And I lived in Christina's house from 2014 through 2018 before we moved to my house in Vernon.
Okay. And do you recall when Mr. Rodriguez, how long he was at the halfway house?
I do not recall how long he was at the halfway house. I do recall moving him from his dad's house in San Antonio to his mom's house.
Okay, and do you know when approximately that was?
I'm gonna say it was September, October of 2014. I remember it being very hot.
Mhm.
Okay, and because I had to go over to their house or his dad's house and had a lot of clothes. I helped him pack up the clothes and put them in the vehicle and leave.
Now, was he seeing Emily at this time?
I
That's just
do,
speculation, Your Honor.
Emily? Yes.
All right, that'll be overruled.
And so, did you ever notice anything untoward towards Emily, between Emily and Mr. Rodriguez?
No. I would typically watch Emily on Saturday mornings on Saturdays because Alex was working and typically we would go to the park. We may go shopping. There was nothing ever different about her the entire time.
Okay. And do you believe that he is guilty of what he's being charged with or convicted of?
No, I do not believe he's guilty.
Okay. And during your camping trips, did you ever notice anything odd
No,
or inappropriate?
no.
How was, Mr. Rodriguez as a pseudo stepson?
Repeat the question.
How was he as a pseudo stepson?
It was good. It was good. He was always polite. He's passive. Respectful. I always did what I asked him to do.
And did, Emily ever outcry to you?
No,
Okay. Where did Emily sleep typically?
repeat the question.
Where did she sleep typically?
She typically slept with Alex in his room.
And did you ever notice any inappropriate behavior by either one of them?
No,
Did you ever hear anything?
no.
Do you recall when she got her period?
I remember being at the house, yes.
Do you remember what year it was?
I'm gonna say it was, I'll be honest with you, I think it was around 2019.
Has or Emily's mother reached out to you for money?
No,
Not recently.
no.
After the allegations came out, what, 2 years ago?
Mhm.
Did she reach out to you and your wife, your girlfriend for money?
Objection to hear
Come
from Your Honor.
If you could repeat the question, please.
Yeah, did she reach out to you for money after the allegations came out?
All right, the
Correct.
objection will be overruled.
Of course.
No,
And do you still have a relationship with Emily?
I would say it's been, just because what's going on, okay? It's been difficult. We'd like to continue to have that relationship with her. We did, during this process, we did last year go to vacation together, so.
So, yeah, while this case was pending, and Alex was in custody, you went on vacation with Emily?
Yes,
And during that vacation, I believe your wife testified to this, or your girlfriend testified to that. Did she make apologies for what was happening?
Objection to speculation, Your Honor.
Oh, hearsay will be sustained.
Did you observe Emily's testimony from the gallery?
yes,
Okay. And knowing Emily and her reactions, did you find her reaction to the testimony, to the questions to be odd?
Objection to speculation, Your Honor.
With regards to speculation, that will be overruled.
I would say yes, it was
Why?
odd.
Why was it on?
She seemed calm. During her testimony.
And how did her reactions seem? Did it seem out of line with how she typically responds to the questioning?
Objection, Your Honor, speculation.
Overrule as to speculation.
Yes.
Is there anything you want the court to know about Mr. Rodriguez?
It was a great day. He was always there for Emily. Again, always respectful, calm. I never saw him as being aggressive or anything like that. Okay. Listen to his mom, listen to me. I thought it was a great day. Still do.
I pass the witness.
All right, state.
Yes, Your Honor. Good morning.
Morning.
And I guess I'm a little unclear. How do you know the defendant?
Christina Ontiveros,
And who is that?
Alex's mom, okay, we're domestic partners.
Domestic partners?
Yep.
Y'all live together?
Yes,
Okay, so you live with the defendant's mom
yes,
and you started living with her in 2014?
2014. Mhm.
Were you in Alex's life before that?
No,
Okay, so you've only known him from 2014.
yes,
And since that time, he had been seeing Emily.
yes,
Okay, so since 2014, he was seeing Emily. She was coming over and staying the night
on every other weekend, yes.
every other weekend. In 2014, she was coming over, staying the night, and sleeping in his room. Is that correct?
Pretty much from the time he moved in, yes.
And how do you feel towards Emily?
I love her like a daughter.
You love her like a daughter.
Yeah, granddaughter.
How do you think she feels hearing you say you don't believe her?
I couldn't answer that question.
But you love her like a daughter.
Granddaughter. We miss her.
But you don't believe that she was assaulted.
No.
So then you wouldn't be protective of her.
Would be protective of her.
You said you never noticed any inappropriate behavior, but Emily was sleeping with her adult father in his room at night.
Yes,
You'd agree with me that these types of crimes, these sexual assaults of children typically happen behind closed doors, right?
Objection, speculation. He has no knowledge of.
All right, with regard, you can answer the question if you know the answer.
I don't know the answer.
Well, do you think people go around assaulting children in broad daylight?
Objection, argumentative, and speculation.
Sustained as to argumentative.
I'll move on. When you were at these camping trips with the defendant and Emily, they would sleep in their own tent together?
Yes,
You guys weren't, you and Christina weren't in the tent with them, right?
no,
So you wouldn't know what was actually going on in the tent.
no.
And when Emily would go over and sleep in your house, in the defendant's room, you wouldn't be in that room, right?
No,
So you wouldn't know what went on in that room at night?
no.
And in your opinion, would it be smart for people to commit crimes in front of other people?
Objection, speculation.
All right, that'll be overruled.
I wouldn't know.
Would you commit a crime in front of somebody?
I wouldn't commit a crime, period.
Questions, Your Honor.
All right, is this witness excused?
Yes.
All right, you may step down if you'll leave the microphone. Defense, call your next witness.
No, no further witnesses, Judge.
State, any rebuttal witnesses?
If we can have just one moment, Your Honor, I had someone checking on something.
All right, thank you. All right, Norma, while they're doing that, if you can see if Mr. Sawyer is here. I think I saw him pop his head in. So that we can take care of this matter. All right, thank you.
Nothing further to say at this time, Your Honor.
All right, Sydney, we're back on the record. State, do you rest?
State rest, Your Honor.
Defense, you rest?
Defense rest.
All right, both sides close.
Rest and close, Your Honor.
All right, the court will hear argument. State,
Yes, Your Honor. Your Honor has. Your Honor has heard all the testimony in this, not only during the trial, but during the sentencing right now. Your Honor is aware of his prior conviction for arson and what he claims is the reason for doing it. This defendant is the victim's father. fathers are supposed to support and protect their daughters and be good role models for them, teach them about relationships and how they should act with their significant others, how they should be treated. But not like this, Your Honor. That's not what the defendant did. He didn't show proper love and trust toward his own daughter. The defendant twisted and destroyed everything, every aspect of his fatherhood towards this victim. Every part of her body was violated by him, as you heard. She underwent 4 years of abuse. She was 6 to 10 years old when this happened. Her innocence was taken from her. She did not grow up as a normal kid should, and she's gonna have to deal with this the rest of her life, essentially serving her own life sentence, Your Honor. He penetrated her anus with his penis. He touched her vagina and her breasts. That is not how a child should be treated. That's not how a child should be growing up. You shouldn't get to benefit off of this. Other people's faults don't lessen the severity of his actions. He's been found guilty by a jury of his peers, Your Honor. And the state's asking 50 years TDC, count 1, 20 years TDC, count 2, 20 years TDC, count 3.
All right, defense.
Yes, Your Honor. Can I stay seated or should I rise?
Oh, you can stay seated.
Your Honor, this individual was released from custody in 2013. He went to a halfway house. Testimony at the hearing in trial by Clarissa even stated that, you know, she would go visit him in Corpus. And so I don't think there's any doubt that he was in fact in Corpus in 2013 and migrated to San Antonio in 2014, which would put her outside of the indictment range. You heard from Emily, she was all over the place. She doesn't know if she was penetrated or not. I don't know how a child can testify that she wasn't sure if she was penetrated or not anally, especially one that is this old at this period of time. She went through, I think, 6 months of therapy, 3 months of therapy, and she was done. Her grades have not been affected according to her. The outcry was severely delayed. And then law enforcement took 2 years to investigate and to arrest my client, thus leading us with very little ability to do any kind of investigation, forensically or not. We showed the jury pictures. I was quite flabbergasted by the fact that they came back with a guilty. I do not believe the state has met their burden at all. But in that respect, we have to proceed with sentencing. And so we would ask that for the minimum on each count. Obviously, you know, my client has the right to appeal and we will seek an appeal and likely a motion for new trial. So at this time, we would ask for the minimum so that we can proceed with our appellate review.
All right, so the evidence that was presented to the jury was the evidence that was presented to the jury. And it appears that I'm being asked to make a sentence based upon that this evidence that was just presented proves what I'm hearing from the defense, proves that he is not guilty of count 1. I'm merely here to do sentencing with regards to defense saying, let me present this evidence that wasn't presented to the jury for the court to somehow give a sentence based upon evidence that the jury never did hear. It seems as maybe that's evidence that should have been presented to a jury. A jury made their decision on a verdict based upon the evidence that they received. So my understanding and my recollection from the first phase of the trial, the defendant did not testify. Is that correct?
That's correct, Your Honor.
No evidence was presented to the jury that he was in custody from February 26th to 2009 and paroled in November 19th, 2013. And the indictment for count one says on or about November 11th, 2013 through November 11th, 2017. So that wasn't evidence that was presented to the jury. So the court is making its ruling on sentencing based upon the evidence that the court has heard. No one has asked that. Well, I don't recall anyone asking the court to consider trial testimony. However, according to case law, whenever sentencing is being done, the evidence presented at trial is to be considered. So the court is considering that. And State, I believe you wanted to say that you asked that I consider that.
And there was another point as well, if you'll allow, Your Honor,
Yes.
that in the victim's own testimony during trial, she stated her own age at the time of the abuse of 6 to 7 years old, which would coincide with the time that he was released from prison. So despite the fact that the prison records as they've been presented to you today were not admitted to trial, that evidence was obtained through the victim's testimony to the jury.
Oh. And I'm sorry, yes, I do have a trial court certification of defendant's rights to appeal. All right. All right, this is what the court is going to do. And count one, count two, count three will run concurrently. Just one moment. With regards to any fine, anyone wishes to address the fine?
My,
Time, you said, Your Honor?
Fine.
Oh, fine. State will defer to the court.
and my client's indigent.
All right, well, the fine, no one knows where that fine actually ends up. I know what the law says where it should go, but no one knows where it goes. So the court is going to order a $0 fine. With regards to restitution, the court did not hear any evidence concerning any type of restitution, so the court is not going to order restitution. There's to be Chapter 62 registration, and sir, that's a lifetime registration. There's to be no contact with the complainant. While the complainant is a minor. Unless there's someone who is requesting that there be no contact.
We would request that, Your Honor.
Without the exception.
I was under the impression they got a protective order.
As well, Your Honor.
Okay. Well, protective orders, is it a lifetime protective order? If it's not a lifetime protective order, then protective orders expire. So my question is, do y'all want to speak to the complainant and see if she wants a no contact order forever, or if no contact order while in custody?
If I may,
Yes.
speaking with the victim, she is requesting lifetime no contact.
All right, there'll be no contact with the complainant, and if for some reason the complainant decides she wants to have contact, then that's something that she'll have to arrange, but you're not allowed to have contact. Do you understand? All right, and when I say contact, that means all contact, no letters, no cards, no contacting through third parties. Do you understand? All right. And then in count one, the court will sentence you to 30 years in the prison. Count two, the court will sentence you to 15 years. Count three, the court will sentence you to 15 years. Court will give you credit for any time served. Is there anything else with regards to sentencing?
Nothing from the state, Your Honor.
Nothing from defense. Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And I'm sorry, counsel, he needs to sign this?
May I approach?
Yes. Thank you. Thank you. All right, Mr. Rodriguez, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? All right, this is not a plea bargain case. You do have a right to appeal. Because this is a felony conviction, here's your copy, counsel. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, any questions before we go off record?
Not from the state.
All right, is there any victim impact?
There is, Your Honor.
All right, just one moment. All right, to you, Mr. Rodriguez. See the file for Mr. Sawyer's client, please?
Are we excused, Your Honor?
Yes. Oh, if y'all will make sure that the court reporter has all the exhibits, Cindy, here's this.
Hey, Judge, I think there was a motion for investigative funds on this case. I'd rather, I think they gave it to you.
That has already been signed. For the funds. Yeah. Now I sign everything that's given to me. I know that it's being reviewed, but I've signed it.
Okay,
All right,
thank you.
sure. You're welcome. All right, on grant, there's supposed to be paperwork. Okay.
Oh, I would love that. Yes, that's what I'm saying. I thought that's why you were saying that.
It's just all.
Yeah.
See the big about.
I only saw the Cowboys. Watch the federal convention. Yeah. Is that all that we have to say? You guys still down here?
Just one please.
Sure. Good morning. You're walking like you're hunting rabbit. You know, moving very slowly.
Rabbit hunting.
Mhm.
rabbit. This client of mine has made bond. He has a GPS requirement. The family cannot afford that. So I have filed these motions to have his fees waived if the court could accommodate that request. And you will not have me to kick around next week,
Where are you headed?
the Dominican Republic.
Oh, what are you doing there? Vacation?
We're gonna do some water slides. Oh, yes, absolutely. Some snorkeling,
You going?
some zip lining. The Dominican? Wish me luck.
Oh, so when do you leave?
Tomorrow, I'm sorry, no. Friday morning at like 4 a.m. Like an early flight.
How long is that flight?
Well, we fly to Charlotte, and then I think from Charlotte to Punta Cana is about 3 hours. It's like flying to Puerto Rico. So not terrible. But
Or flying to New York because you get the delays?
yeah.
And a trip that was supposed to be short turns into,
Don't say that.
Yeah.
I have such bad luck with that.
no, I think you're gonna be fine.
The last trip we took going out and coming back, we had issues and it sucked. We got trapped in
Well,
Dallas overnight.
I would tell you what, check the weather because you know they have that large
I do.
tsunami.
I have
I don't know where it's now.
tsunami
Oh,
in the
you never did
Caribbean.
this?
No.
I always track
Oh,
everything
no.
that's related to zombie apocalypse. No, there was a major tsunami because there was an earthquake and it's gone to Japan. And of course, Hawaii is close. So it's in Hawaii. You haven't read about this?
Have not.
Oh, yes.
Well, we're on the other side of the
Well, I don't know. They're saying
Okay.
it's hitting different places. Let me see what it says.
I do know there's no hurricanes
Yeah, but they have
in the region.
they have a tsunami watch. So they say there's a massive 8.8 magnitude earthquake.
Wow.
So there are evacuations and tsunami warnings across Hawaii, California, Japan. They don't know how far it's going to go. I know where you're going, but they say that for some reason this season is going to be the worst weather season. So you may want to just check
Yeah.
before you go.
I usually do.
Yeah.
I keep kind of monitoring. I did not hear about that, though.
don't have me seeing you on the news.
Hmm.
Oh, and that earthquake was in Russia. So don't have me seeing you on the news or my mom seeing you on the news where you're at the airport. She's gonna call me. I think I saw Toshi at the airport. Send food.
Yeah, he's trapped.
Yeah.
He set up a GoFundMe. Yeah, we'll see how it goes. The Dominican should be okay, but I've heard let's head on a swivel when you're there.
Yeah, that's on my list. I have a lot of things on my list. I still haven't gone to Amsterdam.
Hmm.
So I want to do that. My problem is when I enjoy a place for travel, I tend to continue to
Go
go
back.
back there.
Yeah.
And people are like, Stephanie, stop going to Paris, stop going to Greece,
Well,
stop going to Scotland.
I mean, they're both strategies. You know what you like, and
Yes.
so you know what you're getting. And it's like restaurants. Like, I want to go to these restaurants. I like these
But
restaurants.
see, my thing was Costa Rica and some of the other places, like even Hawaii.
Rica's great.
Like, okay, what am I going to do there? For someone who's not a swimmer, what is there for me to do? Do I just relax and look at the waves?
Eat some good poke, hike,
Okay.
I don't know,
Okay.
golf. They have great golf. In
Oh,
case you didn't know,
yeah.
try that.
Yeah.
Yeah, I don't know.
I'm telling
Stephanie
you,
Boyd has to figure that out.
if I were still doing CLEs, I would actually do another one in Scotland.
So you didn't have.
And then people could go to
Yeah.
was
St. Andrews.
That's it.
It would
Do you,
suck.
I would. Do you remember when I was a baby?
I know.
Every year they'd go to Cancun. I remember there was a defense bar in Cancun every year, and I never went to it because
Okay,
I
sure.
could afford it. I don't think. But like, why did that stop? Because we can do that.
Well, you know what I did? So when I was president of San Antonio Black Lawyers Association, I said, we're gonna do CLEs. And we're doing, I said, if they can do CLEs in Vegas, why can't we do them in different countries? Do sort of like comparative studies? And people are like, it can't be done.
Yeah.
And I said, we're gonna do it. So we did it, and the first one we did was Paris and London. Virginia Maurer went. And then after that, we did an Italy one. We did a Greece one, and we did a Scotland one.
And I think you get deductions, don't you? Because it's
Yes.
related to your law.
Yeah.
Yes.
And so everybody enjoyed it. And I tried my best to keep the group as small as possible because I wanted us to pick the times that we would do certain things. Of course, visiting court houses, you have to visit them within a certain
Do
time.
you have to get those approved by the state bar? Is that the
Yes, they
deal?
were.
But they would approve them?
Yes. And so we would go
I don't know if it's true.
and you would have to do a specific number of hours per day. And so usually those trips that I would arrange, it would be about 30 hours. And I would get people to come and speak. And so I would have, it would be a group of about 10 of us or 12 of us. And I would say, look, this is our schedule, because some of them would be speakers. I said, do y'all want to do this early in the morning? This is how many CLE hours we have to do each day. Or do you want to do it in the afternoon or in the evening? Everybody's like, no, everybody's like, let's do this early in the morning, then everybody can do their thing. And
You can have dinner in the evening and have drinks and
well,
hear speakers.
here was the awesome thing about it. The very first day we were there, we all had just a long, long breakfast. And the speaker spoke while we were having breakfast. And it was sort of informal, which made everybody remember everything, because you could just say, oh, and excuse me, what did you just say? Is that really what the law is? And then there would be this discussion. Then they go back and, I'm drinking my hot chocolate. And people said, oh my gosh, I now remember all of this. And they really enjoyed going to the courts. When we were at the court system in Paris, it was so funny because my French started coming back to me. So we're in this misdemeanor court and they're talking. And I'm picking up on the French and I'm like, good gosh almighty, this guy is saying he didn't have this money because it was a drug case and they had found about 8,500 euros on him or something. And so his attorneys were saying, hey, we have the witness. He wasn't selling drugs. And someone from Vegas asked him to hold $8,500 for him, right? And they're like, this witness should be allowed to testify. And the judge is like, no, we're not allowing him to testify. We're here for sentencing. I'm sitting there thinking about the injustice of it all. Because in the middle of the defense attorneys arguing, saying, there's this witness, guess what ends up happening? The doors open, a guy from Vegas comes walking in.
Says, where's my money?
You know, I'm the guy. And the judges were still saying, no, he is not allowed to testify. So they wouldn't let him testify. And I was like, oh my gosh, Paris, be still my heart. This is insane, right? And guess what ends up happening? So I'm sitting next to the person. I'm just so dejected by the whole system. And I said, so how much time did they give him? I said, after that, I couldn't even listen anymore.
Yeah.
And the lady says, oh no, they were arguing over the amount of community service hours. That was what this is all about. So that was the whole argument over the community service hours. So he was presenting this guy for that.
Yeah.
And then we went to see the felony court and how they did things. And then in Scotland, we were just there when they were trying to, I don't even know if they changed the law of double jeopardy, because supposedly some guy was found not guilty. And he did what people always tell their clients not to do. The court of justice said, I did it.
That's,
Yes. And he's like, I did it. Cheers to me. And so they were trying to do a new law where even though you're found not guilty, if new evidence is presented, you can be retried.
He's the cousin.
So you can thank him if that happened.
Okay, you know, sure, all right, you know, I don't know. I
They
won't.
all
thank
do,
you.
'cause it's still a very small.
I like Cayman Islands.
Oh, okay.
I'm gonna look into this.
All righty.
Thank you.
Well, enjoy. Hi, John.
Hey.
How's it going? You're here for something?
Well, it's someone that I talked to you about the other day, and you graciously allowed him to appear on Zoom tomorrow because he's pending mental health court.
Yes.
Tomorrow is Monica Guerrero's sister's funeral.
Oh, yeah,
And
yeah.
so I need to go to that. So I was going to see if I could bump it a few days.
All right.
He's also, just to let you know, Judge, he has his home visit from mental health court on Friday.
Okay.
So it looks like he's in. They're just doing the final things.
All right, Norma. Can you recall this? You want to do it the first week or second week of August?
That'd be fine. I'm here. Yeah.
All right.
Whichever.
If you'll confer with Miss Ferguson on a date.
Awesome. Thank you, Judge.
You're welcome.
Have fun tonight.
All right, thank you.
Sure.
Yes.
Good morning, Judge.
Hi, just give me 1 second. Let me put this in the system, then I'll take up your matter.
Thanks. Actually,
All right, Norma, what date?
the 12th.
Okay. And your client,
Yes, ma'am.
yes, he wasn't appearing by Zoom for this 12th date, is he? I don't know if he can Zoom.
My client for tomorrow was gonna Zoom.
Yes, so I can put him down for the 12th for Zoom as well.
That's fine. And Judge, I was just telling Norma that more than likely he'll be admitted into mental health court by then, so the case might be dismissed by then.
Okay,
So
all right, thank you.
thank you.
Norma, here's that one.
Yes, ma'am.
Oh. Something.
Sure.
All right, so Trey.
Sorry.
I am back on, I think for the third time on this lady.
Mhm.
She was originally set on Friday. You would agree to let her move to Monday. She was released to the hospital, so she was set to appear tomorrow by Zoom. We're trying to see if we can possibly move that to Friday. I think my understanding, there's a combination of issues. She has the health issue still. She is also, I guess, set to appear in Comal tomorrow that we weren't aware of when we requested Wednesday as a setting. I believe that Comal County setting is going to move anyways because of her health issues. She's not able to get to court. We're just trying to see if we can have her appear on Zoom to plea on Friday. It is going to be a plea and the case will be resolved then.
Well, I can't do it on. Norma, do you want to do this plea by Zoom on Friday?
Friday?
Yes, that's what defense is saying, correct?
Yes, that's what we're requesting, Judge.
It's been a case that we've been trying to take care of for a while. I have no idea.
No,
Here.
I'm sorry, Your Honor, I don't have the terms of the plea in front of me, and I know Robert is gonna be handling the plea. If you want, I can step back, Judge. I can find out the exact terms of the plea and I can come back and let you know.
Sure. And Norma,
Yes, ma'am.
could you have family violence come down, please?
Yes, ma'am.
All right, are y'all ready on Mr. Grant? All right, Mr. Grant, if you'll come forward. And Ms. Abrams, this is this an application?
Yes. This is deferred, Your Honor.
All right, this is an application. Court is calling 2025 CR 004-264, State versus Joe Anthony Grant. Can I have parties announced?
Up to the state of Texas, Your Honor?
Michael J. Sawyer for the defendant.
And are you Mr. Grant?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Grant, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, we are.
Mr. Grant, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
Did you understand you're charged with possession of a controlled substance, penalty group 1 to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, I did.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
I did.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Grant, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's an $800 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes,
Is that
Your
the
Honor.
plea? I'm sorry, I'm looking at you when I said that. State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offers State's Exhibit 1 and all attachments at this time around.
Defense has no objection.
Mr. Grant, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
I believe the court needs is in the report, Your Honor.
All right, Mr. Grant, who is this Brianna Nicole Martinez person? All right. Are you employed?
Self-employed, I work friend, they call me to go do work.
What do you, what type of work do you do?
Contract, electrical, plumbing, like we do nail salons and
All right, do you live by yourself?
I live with my parents.
All right. Any minor children in the home? So how often have you been using? And when did you start?
Don't know. Couple of years.
Okay, so how often have you been using?
Don't really know, like off and on.
All right. When's the last time you used? And let me just tell you, I'm going to grant your application for probation. You're telling me that you've used before you came to court. That's not a violation of your probation because you are not on probation.
No, I haven't used.
All right, so if you're drug tested today, what are the results going to be? And I have the ability to have you drug tested today.
Everything.
All right, so when's the last time you used?
Probably a month ago or so.
All right, so what are you doing to maintain your sobriety?
Nothing right now.
Well, I mean, how do you not use?
Excuse me?
I mean, when you have a craving or you're thinking about using, how do you stop yourself from using?
Go to sleep.
Oh, okay. All right. This is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. There's to be a TAP evaluation out of custody. I'm going to want 60 sober meetings in 60 days. There's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 4 months. Sir, how old are you?
57.
All right. There's going to be 200 hours of community service restitution. So once you've completed the court's requirements of the 60 sober meetings in 60 days, if he continues doing his sober meetings, for every sober meeting that you do, I'll deduct 2 hours of your community service restitution. Otherwise, you're welcome. Otherwise, you know what's going to end up happening? They will have you picking up trash in this heat. All right, is there anything else?
Nothing further from the defense.
There's one thing from the state,
Yes.
Your Honor. The state may have neglected to include a condition of restitution for $60 to the Bexar County Crime Lab for the labs. We believe it's standard with these pleas.
That is standard, we have no objection.
All right, so there's to be $60 restitution to the county lab for drug testing.
Nothing further from the state, Your Honor.
All right. Anything else, probation?
No, Judge, I'm sorry, $60 to SAPD or Bexar County?
It is, let me see who the lab is. It's the Bexar County lab.
Thank you, Judge. No.
All right, is there anything else you need to be successful on this case?
Mm.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Mm.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
So in this court to be, we can go off the record, in this court to be successful on probation, communication is key. If you do feel that you're going to use or something's going topsy-turvy in your world, just pick up the phone, call probation, let them know. If they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you, sir. And thank you for dressing it appropriately for court, but you always do. I appreciate that. Thank you.
That's all I have, Your Honor. Maybe excuse.
Yes, thank
Have a
you.
good day, Judge.
There's no fine. Yes.
Just Spear and I wanted to approach about cases on your docket tomorrow, Judge.
All right, you all want to pull the file?
I can.
Mr. Martinez, you need to see me concerning?
Judge, if I could.
Mhm. You may see you tomorrow. I remembered my pinks. Wednesday, yes, we wear pink. Yeah. All right. Yes.
Your Honor, it is going to be for deferred.
Okay. All right. So just speak to Ms. Ferguson and see if we can put it on Friday's docket for a plea.
Perfect.
And Norm, if you'll let
Gotcha.
the defense attorney, I'm sorry, the state's attorney, see if they can have the paperwork for him.
Email him.
All right.
But I know, but Sean's gonna have a, because it might to do the. So I don't, right.
It's for Gabriella.
Do you have their?
All right. Yes.
I did, yep.
Yes, I have it. Warrants.
So it's
sure,
not for
yeah.
plea deadline, Judge, but I'll let Steve speak for himself about that issue.
Yes, Judge, it's set tomorrow for the plea deadline.
Mhm.
This is one that I have to get approval by the DA. After we talked, I believe it was on Monday. I previously got an offer
Mhm.
from the DA. However, the information that was there's actually something different. So I needed to so I could give a formal offer. I've given him one, but it's not with the incorrect information that Joe had. So I did schedule a meeting. However, he could not meet until Friday. So I wanted to see, I didn't want to waste everybody's time if I can't give him a formal offer. I will know on Friday. I think I'm meeting with him at 11. So I didn't know if the court wanted to, I mean, certainly can come tomorrow. I just can't give him the formal offer until
All right.
later.
Your final plea deadline date will be Monday.
That should work perfect.
All right.
So,
I'll be back then.
All right. Thank you.
thank you, Judge. I appreciate it.
And you'll let your client know?
Yes, I will. Judge.
Oh, Mr. Martinez.
Yes, Judge.
So I received a affidavit to surrender surety on your client Mullinex. But I let them know that George, he's under a judge's warrant already, so you may want to check with the bondsman and see what's going on.
Is he not in custody, Judge?
I'm not sure.
Well, I knew he had a warrant, Judge, because I don't think he made it to the last setting.
Yes.
But I don't have a issue one way or the other if you want to sign the affidavit of surety.
Well, I did the judge's warrant, but if I sign the affidavit to surrender surety, one, legally, there's already a judge's warrant.
That's right.
So, but once that's signed, the affidavit to surrender surety, then there's not going to be any restatement of bond because I know the time is going to run.
Yes, totally understand.
All right, thank you. Norma, that case, I've just set it for the 4th. All right, is there anything else from anyone? Shocker of shocks. Should I say it? I'm gonna jinx this by saying it.
You already did, Judge.
No, we're done for today. Unless somebody wants to call up a jury for another trial. Yeah, okay. All right, Deputy Laura, I'm being, Deputy Bahia, Deputy Laura, I'm being asked to let's just pick a jury for my trial.
After yesterday, absolutely.
Well, I have a scopus that. So I just sent to her first, right?
Yeah, they'll let me know that it was, see if I can get it through.
Okay.
Okay, excuse Judge.
Yes,
Oh,
thank you. All right, see you then.
Yes. Well, that's in the-
Oh, thank you.